All right, let's begin Module 4. All right, welcome back for Module 4. Module 4 regards corporate authority. So, as you learned in the other modules, shareholders might own the corporation, but the directors run it. And so directors have the authority to run the corporation, and they can delegate that authority to others. And it's actually somewhat complicated because delegation of authority creates agency problems. And so we're going to look at a couple cases first to sort of explain the issue, and then we'll back into some principles. Let's start by discussing, again, who runs a company. So shareholders do not run a company. Shareholders own a company. They're owners, and the directors, who are the fiduciaries, are responsible for running the company, although they may appoint executives, such as the CEO or CFO, to run day-to-day affairs, and they may make only high-level seminal decisions like appointing those individuals. And of course, there are employees in the company as well who are responsible for many of the actions of a company. So how does a person have authority to run a company? So there are different theories that provide authority. The easiest one to understand is express actual authority. Express actual authority is when the board of directors, in a written consent or a resolution at a meeting, says, you, CEO, are authorized to do such and such. CEO is authorized to sell this corporate asset, sell some company land to such person at such price. When you get an authority like that, it's very clear that the board has approved something. So one way that a person doing what's called diligence, which is when a corporate attorney looks through records to determine evidence of authority, would look and see if there's any board resolutions on point, which actually say such and such person was authorized to take so and so action. Authority can also be implied. So, for example, if a CEO has sold land any number of times before, there could be an argument that another sale of similar land could be implied, or more commonly, you would see that within the scope of executing one type of task that is expressly authorized, other things are implicitly authorized. So, for the CEO of a company to sell land, he may have to negotiate. So the negotiation for land is going to be it's going to be implied and not expressed by the actual express grant of authority to the CEO to sell the land. He has an implied grant of authority to negotiate for the land. So another theory can be apparent authority. So I picture here, this is the whispering in an ear kind of theory. So if you are sitting across the table from the Godfather and you see him whisper into his consigliere's ear, and the consigliere then speaks to you, you may interpret from that, you might form a reasonable belief that what the consigliere says is authorized by the Godfather. Because you actually watched, you had a physical manifestation, you experienced the manifestation of a grant of authority, which caused a reasonable belief in you that the agent, in this case the consigliere, was authorized by the principal. There's another and somewhat more contentious idea that authority can be inherent in a position, and this can essentially be understood as a way for courts to manage rogue agents and who bears responsibility for rogue agents. So our first case will have a rogue agent where a CEO went and executed a sale of land without the permission of the board. In fact, with the express lack of consent, the board said, don't sell that land. You're not authorized to do this transaction. Went and did it anyway. And here we see that the law has this concept of inherent authority, that this person, because of the nature of being a CEO, was reasonable even without that manifestation. So the difference here between inherent and apparent authority, if something caused you to have a reasonable belief, something appeared, you had a manifestation, the whispering in the ear, that gave you reason to believe this person had authority. In the case of inherent authority, you never saw the Godfather whisper the consigliere, but you know that the consigliere acts for the Godfather. And so when the consigliere speaks, you believe reasonably that the Godfather authorized that action, and it is incumbent on the Godfather to police his consigliere. And so essentially the way that this law works is that inherent authority is a way that we cause corporations and boards to be responsible for their own directors, because if there's a transaction and it wasn't authorized, who is left holding the bag? Is it the person that mistakenly but reasonably believed that the transaction was authorized, or is it the corporation who didn't monitor their directors? In this way, inherent authority is seen as a way to have a corporation be responsible for that sort of problem. So the board of directors runs the company. They hire and fire the CEO. A couple things you should know about the board. One is that they act as a group in concert. Each director has no power. They have power as a board, and so they meet as a board. And when they meet, they must have a quorum, which is a required number of directors present, in order to authorize a resolution. And then when they vote, they need to have a certain majority or supermajority, depending on the bylaws or the rules of the company or the rules of the state, to approve that transaction. Directors can meet either at special meetings or at scheduled meetings. For scheduled meetings, since they're scheduled, no additional notice is required. But for a special meeting, which can be convened, for example, in a hurry in order to approve a merger or deal with some desperate crisis, there are notice rules because we don't want the directors to call a meeting and exclude a director by virtue of having the notice be too late for them to actually attend. We want the directors to all be able to attend and be present, give them that opportunity. So when you look and make sure that a board decision was approved, you make sure that there is due notice of the meeting, that there's a quorum at the meeting, and that a proper majority attended. An alternative to a meeting, instead of a meeting, in lieu of a meeting, the directors can sign a written consent. And in Delaware, it needs to be unanimous written consent, meaning all the directors need to sign. So at a meeting, you don't need to have all the directors agree, but not at a meeting. If they agree to do something outside of the meeting context, they all have to agree in a unanimous written consent. When the directors make a decision, as opposed to when they make an inaction potentially, but when they make a decision, it's subject to the business judgment rule. This is good for directors. The business judgment rule is very pro-director. Basically, the business judgment rule, which we discussed in much more detail in Module 8, says that if a decision is informed and deliberate, meaning it had the proper amount of paper and process, the directors will not be personally liable for making that decision. We don't want directors to feel liable for risks that they take, so long as they're good, reasoned business risks, because we want directors to take risks. We don't want to make them personally responsible for risk, because we want corporations to take risk. Without taking risk, they would be able to earn profits. Business judgment rule protects directors. So let's look at our first case. What happened in this case? Menard Inc. versus Dage MTI. So here, Sterling, who's the president of Menards, offered to buy a third of a parcel of land from Dage, and the Dage board rejected the offer. And then the Dage board went and told Sterling that Sterling was to clarify, the president of Dage MTI. The Dage MTI board told their president Sterling he was not authorized to negotiate the sale of land to Menards. However, regardless, he made he got a second offer from Menards for the full parcel for $1.5 million and continued negotiations. Even though the board expressly told him not to negotiate, the president went ahead and negotiated anyway. And then he negotiated, not only negotiated, but negotiated and signed on behalf of Dage MTI without informing or seeking consent. The transaction closed, and 4 months later, 4 months is important here, they sought to rescind the contract. So who is responsible for the unauthorized sale of land? In this case, the president is responsible. The board is responsible because they failed to police their president. Again, this is the case of inherent authority. What this case demonstrates is that the board shall be responsible for their rogue president if a person on the other side reasonably believed that they were authorized. There was a dissent in this case, and you should read it to understand the nuances. The evidence of authority can come from many places. So as we mentioned, one evidence of authority comes from the board consent or the board resolutions, but it can also come from state statute. Some states grant certain powers to certain officers and directors just by virtue of their status in that state. The articles of incorporation or charter can also be a place where people get certain grants of express authority, so look to there when doing your diligence. The bylaws may also describe the duties of a president, and if something's within the scope of the duties, there is a claim there that it's either expressly or impliedly granted in that way. And of course, board resolutions and unanimous in Delaware, in some other states, non-unanimous written consents. Also, prior approval of something similar can be construed as evidence that that is a authorized transaction. So for director liability, we're going to look at Module 8, and so I hope you will join me there.